Welcome to the third in our series of 4 short videos in which we take a bite-sized look at some of the ways in which litigation and court orders can affect parties who are not participants in the relevant litigation. In today's video, Donna Newman, a senior associate in our finance litigation team, will be reviewing how parties to litigation go about securing the attendance of witnesses and what options are available to potential witnesses and their employers.
Hello. This webcast looks at the question of whether an individual can be compelled to give witness evidence for civil proceedings before the English court or before a foreign court. Factual witness evidence is undoubtedly an important part of English civil claims, both in terms of a party supporting its case with the evidence of its own witnesses and having the opportunity to cross-examine the other side's witnesses. Cross-examination can cover any relevant matter that the witness can deal with. Generally, appearing as a witness in court and being cross-examined by the other side's barrister is not a nice experience for the witness. It also means taking the time to attend court and potentially the cost of transport and accommodation. Often, witnesses in proceedings involving banks or other financial institutions will be employees at the relevant institution. Whilst giving evidence in proceedings is unlikely to be a pleasant experience for these witnesses, there is not likely to be a problem in securing their attendance. But what about where evidence is required, or at least desired, from someone who is no longer connected to the bank, such as a former employee? Conversely, what if one of the bank's employees is asked to be a witness in a claim between 2 third parties? It is in these circumstances that you are most likely to want to know the answer to the question of whether an individual can be compelled to attend a trial or other hearing in order to give evidence. Looking first at the situation where you would like to obtain witness evidence for use in English proceedings from a witness who is not prepared to give evidence voluntarily. If the prospective witness is within the jurisdiction of the English court, it is possible to serve on them a witness summons, compelling them to attend court in order to give evidence at a trial or other hearing. If a witness cannot attend court, for example because they are elderly or infirm, the court may order them to be examined under oath at another location, such as their home. This is known as a deposition. A witness summons is binding if it is served at least 7 days before the date on which the witness is required to attend before the court. It is possible to serve an effective witness summons closer to the court date with the permission of the court. If the prospective witness is outside of the jurisdiction of the English court, then the court does not have the power to compel their evidence. Instead, there is a process by which the English court issues a request to the foreign court in the relevant jurisdiction, asking it to take the evidence and transmit it to the English court. Thus, the ability to obtain evidence from a witness out of the jurisdiction, who is not prepared to give evidence voluntarily, depends upon persuading the English court to issue the request and on the foreign court complying with it. The English court has discretion whether to issue the request. One of the things it will consider is whether it would accede to such a request if made of it by a foreign court. The approach of the English court to letters of request that it receives from foreign courts is discussed later in this webcast. Whether the foreign court complies with the request will vary depending on the jurisdiction and the arrangements in place between England and that jurisdiction. A key consideration, therefore, is whether you are dealing with a court in an EU member state other than Denmark or in a jurisdiction that has signed up to mutual obligations with England. If you are, then you have a much greater chance of obtaining the evidence that you seek. For civil and commercial matters in EU member states, excluding Denmark, there is a common process for letters of requests between courts in the EU, which is governed by the Taking of Evidence regulation. This regulation applies when the English court is the court issuing a letter of request to another court in the EU, or when the English court receives a letter of request from another court in the EU. A request is made using the form annexed to the regulation. The receiving court must comply with the request without delay and in any event within 90 days. If the court does not expect to comply within this time frame, then it must explain the delay and give an estimated time for compliance. there are only limited grounds on which a court in the EU can refuse a request from another court in the EU. One is that the correct procedure has not been used. Another is that the prospective witness has exercised a legal right to refuse to give evidence. Importantly, the court must use any coercive measures to compel a witness to give evidence that it could use in an equivalent matter in its own jurisdiction. In England, that would mean compelling the attendance of the witness before the English court by means of a witness summons. Letters of request from the English court to some foreign non-EU member state courts are covered by the Hague Convention, which would cover the US, or bilateral conventions. Whilst these conventions may not provide the detailed rules on process and timing that are provided by the EU regulation, they may nevertheless be helpful in obtaining the evidence. Requesting witness evidence from a member state court or a convention court is a request for the foreign court to take the evidence in accordance with its own procedures and to transmit it to the English court. It does not enable you to force the attendance of the witness at the trial or hearing in England. Precisely how the evidence is taken by the foreign court and whether or not the parties to the English proceedings are able to attend when this is done will depend upon the laws of the foreign court. It is, of course, still possible for the English court to issue a letter of request to a foreign court in a jurisdiction that has not signed up to mutual obligations with England. The experience with these foreign courts will no doubt differ from country to country, but it would be reasonable to expect less certainty over the timescales, the quality of the evidence, and indeed whether the foreign court will comply with the request at all. Some jurisdictions do not permit examinations pursuant to letters of request. Others permit it only for willing witnesses or willing British witnesses. A local lawyer should be able to advise on the likely reaction of the foreign court to a letter of request. In summary, if you would like to obtain evidence from a witness who is not prepared to give evidence voluntarily, you will need to consider: is the witness in England? If they are, consider using a witness summons to compel their attendance at court. Or, is the witness in an EU member state other than Denmark? If they are, consider a request under the taking of evidence regulation. Or, is the witness in a jurisdiction that has signed up to a convention with England governing how letters of request should be dealt with? If so, consider asking the court to issue a letter of request pursuant to that convention. Information on the conventions to which the UK is or has been a party can be checked on the UK government website. Or, finally, is the witness in another jurisdiction? If so, what is the advice of local lawyers? So, that is the position when seeking witness evidence for use in English proceedings from a witness who is not prepared to give evidence voluntarily. But what about the position when a third party involved in civil proceedings in which you are not involved wants one of your employees to give evidence in those proceedings? For example, what if a party to civil proceedings in England or in Germany or in the US concerning the manipulation of certain rates or markets wants to obtain evidence from one of your employees? Assuming that you do not want this to happen, what are the prospects of resisting? Well, the basic principles discussed earlier in this webcast will apply. If the proceedings are in England and your employee is within the jurisdiction of the English court, the party can serve a witness summons compelling the attendance at court of your employee to give evidence. If the proceedings are in the court of another EU member state, then the English court will deal with the request in accordance with the taking of evidence regulation. In all other cases, the English court will deal with the letter of request under the Evidence Proceedings in Other Jurisdictions Act 1975 and will have regard to any mutual obligations in place with the relevant jurisdiction. In dealing with requests from foreign courts, the basic principle applied by the English court is that it will give the requested assistance to the foreign court if it can, i.e., unless there is a specific and compelling reason not to do so. There may be some, albeit very limited, scope to persuade the English court that the request for assistance should not be granted. There are a handful of possible grounds for objection. 1. The foreign proceedings are not civil or commercial proceedings, as classified under the law and practice of England or of the relevant foreign jurisdiction. Either will do. 2. The evidence would be prejudicial to the security of the UK. A certificate from the Secretary of State is conclusive evidence for the purposes of this ground. 3. The request is oppressive, for example, because it is too wide or too vague. 4. Complying with the request would involve ordering a witness to do something which they could not be ordered to do in English proceedings or in proceedings before the foreign court. For example, because the witness is being asked to divulge information which is subject to legal privilege, as defined by English law or by the law of the foreign court. Either will do. The case of Smith versus Philip Morris provides an example of where the English High Court was persuaded to set aside an order for the oral examination of an individual for use in proceedings between two third parties in the United States of America. In this case, the English court considered the wide-ranging list of topics in the letter of request and the fact that many of them were unrestricted in terms of subject matter or date, and concluded that the examination sought was oppressive. The court said that a witness was entitled to know, within reasonable limits, the matters about which they were to be examined, and there came a point at which a letter of request was so vague that it would not be permitted. However, it is clear that the possible grounds of objection are very limited, and that where a request from a foreign court contains specific questions for a witness who might have evidence to give which will be relevant at the trial of a civil or commercial case, then there is unlikely to be much prospect of persuading the English court to deny the request. If the English court decides to assist the foreign court, as it most often will, it can make an order for the examination of the individual before any person who the court considers suitable. If the witness fails to attend, refuses to be sworn, or to answer questions, ultimately proceedings may be taken for contempt. The examination will be conducted in the same way as taking evidence in a High Court trial, with the witness being questioned by the party's legal representatives before the examiner. The party that has made the request will conduct the examination in chief and re-examination, and the opposing party may cross-examine. In summary, if you do not want an employee to give evidence in proceedings between two third parties, then the prospects of successfully resisting once an application to the English court has been made are limited. For proceedings in England, an individual within the jurisdiction of the English court can be compelled by the court to give evidence at trial or other hearing in England. Note that there is no requirement to provide written witness evidence in advance, i.e. the obligation is simply to turn up on the day and give oral evidence. For proceedings in a foreign court, the foreign court can issue a letter of request to the English court, and the English court is highly likely to accede to that request by collecting the evidence from the individual and transmitting it to the foreign court. The views of the individual or their employer on the matter are largely irrelevant. Instead, the most effective way for an individual to avoid giving evidence may be to make the prospect look unattractive to the parties to the proceedings so that they do not involve the court in the first place. An important point to remember, and often the determining factor when a party is deciding whether to seek evidence from an unwilling witness, is that the party will not know exactly what an individual who is compelled to give evidence will say before they say it. This is not an attractive prospect and is something that the party's legal representatives will be uneasy about. Also, a witness who is compelled to give evidence cannot necessarily be counted upon to spend significant time preparing to give evidence or becoming familiar with the precise legal issues in the case and how what they say might affect those issues. Therefore, an effective strategy may be to simply keep quiet and not provide any voluntary assistance or indication as to what the evidence might be. Remaining a bit of an unknown quantity is often enough to lead a party to decide that compelling the evidence of that individual would simply be too risky.